Okay, thank you, everyone. Thank you for coming or taking time for this. This is the 17th of November, 2021. The Land Use Landmark Committee for Brooklyn Community Board 2. One of my co-chairs, Daughtry Christoffen, is here, and I just want to say thank you again for taking the minutes of the last long meeting. And I'm Carlton Gordon. I don't know if Irene made it, but hopefully Irene and Janners will be joining us today. All right, first we'll get into the agenda. We'll just find out, are there any objections to the agenda?
So moved.
Okay, thank you. And second, I'll second it, thank you. If there are no further objections, the agenda has been adopted. Thank you very much. Next are the minutes from the October meeting. Again, thank you, Daughtry, for that hard, long work. I know it's that was a particularly long meeting, and thank you for that. Are there any objections to the adoption of the minutes?
So moved.
All right,
I hope
thank
you all read them. There were only 10 pages or something ridiculous like that. I always get the long meetings, Brian, you're lucky.
Yes, it's sort of if you're gonna get the best airplane or the worst airplane. All right, thank you very much. It's I have no objections, and the minutes have been adopted. Actually, now what I have to do also, and this is one of our new requirements, is this whole public comments thing, and just give me a couple. I'm going to try to do it as quickly as I can. The Controller's Office has, I don't call it complaint, but has stated to our community board and a number of community boards about public participation and public access to the work that we do. And one of the things that they have shouldered us with, that's the best word I can use, is to have more public comments during the meetings. So we already have public comments at ULURP and BSA hearings, any of those real public hearings. We already carry we allow for public comments. But what we're going to be doing also is on all the other items that we've been voting on, we'll also be asking for public comments. So what'll happen is I'll introduce an item. Let's say we'll be doing the landmark later on, Landmark Preservation Commission item. I'll first ask for public comment on the item, and then we'll get into the presentation and discussion as we usually do. So I think, Caroline, I think I've stated that correctly. Yes, okay, thank you.
Mr. Gordon?
Well, yes.
I just have a quick question. Was it
Yes,
only
Daughtry.
certain community boards that are being asked to do this, or is it across all community boards?
Caroline, you can answer that one. I'm going to throw that one at you.
It's all community boards.
Thank you.
Okay, so, okay. I now carry this additional burden, and we're going to try, I guess we'll try to do it as best as we can. Okay, so thank you for that. All right, now I'm going to move on to, yes, our presentation. And first, this, and I'll just sort of introduce it. One of the things that has come up, especially in many of our smaller brownstone buildings, but anything else, is that what we're concerned about is construction that may affect and deleteriously affect neighboring buildings. We've had a number of people come to us when there's a presentation, and they said, well, what the presenter is presenting will negatively affect my property. It will negatively affect my building. They'll be digging out a base, let's say a lower level, or they'll be doing an extension that's going to affect the buildings next door. And that's something that we've now had to take into consideration. And what Carol Ann Church has done was to contact the buildings department, and we have now have a presenter that will try to address, I think, those issues to us and how we can handle it, how we can work with it, what are the requirements, or let's say what the city would look for. So we'd like to present to you our special guest, Timothy Lynch, PE, from the Department of Buildings, and he's the Chief Enforcement Officer. And take it away, Mr. Lynch.
Okay, hi, my name is Tim Lynch. Can you see my presentation?
Okay, we're still looking at our little box screen, so let's see. Yeah, I don't know if it's.
Mr. Lynch, go ahead and choose share screen at the bottom middle of your Zoom window, please.
Okay, just give me a minute. You see it now?
Not yet.
Okay, give me a minute. Slide screen, okay. That's our guy. Share.
There we go.
Something's happening. There we go.
Okay,
Yeah.
great, thank you.
And
I see orientation slides, building codes, laws.
That's our guy. And that's the only thing you see, right? You don't see my presentation notes, right?
I see something on the corner. It said next slide.
Okay, I'm not worried about that. Okay, here we go.
Okay.
Okay, so my name is Tim Lynch, and this is an orientation in what happens when a development hits the middle of the block and impacts adjacent buildings. Now, I've been with the building department for 17 years, and I was kind of headhunted by DOB under Bloomberg. I came from private to sort of address this particular issue of underpinning buildings in Brooklyn. It actually happened that when I got to the building department in 2005, there was a lot of buildings being damaged by collateral damage from construction next door. And we were getting 2 to 3 partial failures and collateral damages a month in Brooklyn when I joined the building department in 2005. So it was substantial, and we were losing buildings quite a lot. It took us like a year to get it under control. I worked with Tom Fariello, and I left my office, which was Robert Silman's office, I was an associate over there to tackle this particular subject. So I'm going to talk a little bit about the statutory requirements that make it difficult to keep an eye on what's going on with developments in the middle of the block impacting adjacent buildings. Now, one of the problems with this is New York City, we do about 2,500 new buildings a year, and half of them are buildings over 3 stories. So half of the buildings, every building that we only ever do about 2,500 new buildings a year. It doesn't seem a lot considering that there's 800,000 occupied buildings in New York City, but we're only doing 2,500 a year. But they're mostly, a lot of them are in the same kind of areas. We get a lot of them in the downtown areas and the dense urban areas of Brooklyn and Queens and Manhattan. So we're going to address that a little bit. Our codes are minimum standards. So I'm going to talk to you a little bit about the statutory requirements for protection of neighboring properties. I'm also going to tell you a little bit about what's going on with these older buildings today, because they are governed by the administrative code. So we've got 2 governing documents that are the building laws of New York. It's an administrative code book that governs existing buildings. It's very scant regarding specifications, what to do with an existing building. Most existing buildings are governed by certificate of occupancies, and they don't have permits. So the vast majority of buildings in New York City are just running under a C of O. There's no alterations of them, and they are governed by the codes upon which the building was built. Now I'm going to round up on that. This is going to make more sense to you when we go through the presentations regarding the sensitivity of adjacent buildings for collateral damage for a development mid-block or next door to an existing building. If you are doing development of a project next door to a building over 7 stories, the likelihood of collateral damage is minimal. The real problem is unreinforced masonry buildings and wood frame buildings, which are really 19th century buildings. They're really the row houses, buildings, the tenements, the old law tenements, the new law tenements, the heretofore converted and the hereafter converted dwellings. This is a population that numbers about 300,000. So in the 800,000 buildings in New York City, 550,000 are 1 and 2 family dwellings, and they're mostly in the outer boroughs, Queens, Southern Brooklyn, Staten Island. So it really only leaves us with about 300,000 unreinforced masonry buildings that are in dense urban areas. But the likelihood of somebody bumping into one of these things in a development is high for the following reasons. The yield is high on the block because if they're downtown with favorable zoning. So therefore you take a small building down, you get a large building in return. It doesn't cost twice as much to build a 6-story building than a 3-story building. The economies of scale are, the more floors you get, the more economies of scale you get. So that's why it makes it desirable to do these upzoned downtown areas where you get dense urban areas, where you get a lot of density for development. And so the numbers of new buildings is small, but they're all densely packed in these downtown areas where the 19th century brick buildings are. So it's like a double whammy on that. So we're going to talk about some of these building codes, the statutory requirements. I could tell you an awful lot about the good way to do an underpinning job, the bad way to do it, what to watch, but that becomes very opinion based and it's not governed by the code. And it makes it very difficult to challenge engineers and developers on this. So what I want to do is I'm going to lay out the statutory requirements for this work. It gives you a better sense of what we are covered for with the laws. Once you understand where the laws are, you have a better understanding of what you can access for a developer to avoid collateral damage. Now, I'm going to tell you something that a lot of developers know but don't share. When you're doing a mid-block development in a group of row houses and you're underpinning them, whereas the adjacent buildings, the foundations and the cellars are at 9 feet, and the new building needs to be at minus 12 feet, they end up having to undermine the adjacent buildings because the new buildings are just physically lower than the adjacent buildings. And that's the crux of the matter. These 19th century buildings were rarely more than 9 or 10 feet below grade. But the new buildings are actually 12 and 13 feet below grade, which means that when you're doing lot line construction, you're underneath the neighbor. And I'm going to show some diagrams of that in a minute so it can illustrate it. So I'm assuming that nobody knows much about this subject on the presentation, that you have some interaction with this problem due to complaints from neighbors. And I'm going to sort of just orient you on the statutory requirements. Our building code, the purpose of the New York Construction Code, provides is reasonable minimum standards. Now, these are minimum standards, and the minimum standards in the codes they're mostly prescriptive. Okay, there's engineering going with them, but we do have prescriptive requirements. They're based upon current scientific and engineering knowledge. They utilize modern techniques, and it's in the interest of public safety with due regard for construction and maintenance costs. Okay, so we have to be careful here because a developer is bound by minimum standards. They're not bound by the luxury projects that you get in some neighborhoods. They're bound by minimum standards. So therefore, they're designing to minimum standards in the codes. And our codes are prescriptive with some thresholds. Now, there's a lot to be desired in that conversation that I've just had, that statement, okay? But here's the problem with this. I'm just going to go on to the next slide. Existing buildings that are occupied, they're not under a permit. So you've got one thing, you've got a developer that's bound by a building code and an adjacent building that's running under a very old 19th century code because you don't have to upgrade existing buildings unless there was a retrofit required for egress or something. Most existing buildings just run under the code upon which they were built. Those 19th century unreinforced masonry row houses in Brooklyn, they were governed by the Brooklyn Building Code of 1855. And that exists and it had minimum standards. And I'm going to show you some of the minimum standards. Those houses are all prescriptively built. They were sausages out of a machine. They built Manhattan between 1840 and 1880. They built 92,000 buildings in Manhattan. In downtown Brooklyn, Brooklyn City got most of the downtown development before 1901. It migrated into Flatbush and flatlands, but most of the older unreinforced masonry buildings were in Brooklyn City. And Brooklyn City, before the city was consolidated, was bounded by about Myrtle Avenue. So there was building codes that governed the buildings in downtown Brooklyn, and outside downtown Brooklyn, it was pretty loosely coded. Okay, and the existing building codes and existing buildings, the data is scant in them, but it's there. So engineers don't have an awful lot to figure out why these buildings are stable on the lot line, and they're reckless with the developments. Okay, so this is another slide. It's in our administrative code. An occupied existing building is not under a permit. It's running under a C of O. And our building code says the lawful use of an occupancy of an existing building basically may be continued unless there was a retroactive change. And it was built under, and it's still running under the 19th century codes. A lot of people mix that up. They think that existing buildings that are occupied are governed by the current construction codes. They're not. They were really governed by the codes on which the building was built. And that makes sense when you think of it, because you can't keep on upgrading all the buildings every time they change the building code unless there was something found that was prohibitively wrong in the older buildings. It's very rare. So what happens is our aging housing stock in New York City is based on these old 19th century codes. So the buildings are frail. Existing buildings are frail. When you take out a mid-block building to do a development, you unhinge the block on either side. So that's useful to know. So what we're doing is I'm giving you a little bit of orientation of why the buildings are frail. Why? Because they're really 19th century buildings built off a 150-year-old code. And then the developer is not bound by a very high standard for the development of the new building next door to these things, but they are bound by specifications. I'm going to go through this in a minute. There is a specification in our code that says you cannot reduce the fire or structural safety of prior code buildings. And that is one that the developers miss all the time. If you're doing a development, you're not supposed to impact the stability of the adjacent building. That's why I put it up there. You are protected under the administrative code to say the developer is not allowed to diminish the structural safety of the existing building. It is governed in the code. So here's another thing, construction documents. We don't issue permits on a development unless we get a set of drawings. And once we get a set of drawings, we'll issue them for permits. It's in our code. So a general contractor cannot start work on a development unless there's a permit. So we've got that too, okay? And then there's a definition of an engineer. Now I'm going to roll into these in a minute. Inspection of existing buildings. Here's an important thing. When a developer decides he's going to hit up a site in the middle of a block or adjacent to existing buildings, it's important to do inspections of the adjacent properties. And we always have trouble with that because tenants say, I don't want anybody in there. The landlords next door who could be renting the building, you may find that the building is actually not well maintained. The existing building is not well maintained and they don't give access because there may be illegal occupancy. Now, I'm just being frank with you about this issue. When a developer gets to a site to develop in a downtown area with existing buildings on both sides, lot line construction, there is a code mandate for them to do observations of the adjacent properties. Most of the time they don't get access. In our code, it says, make sure these guys get access. Okay? And somebody has to do an assessment of the adjacent buildings. Now, I've put that up there as a slide. Go ahead.
I'm sorry to interrupt you, but there's a lot to get into here, and I appreciate your presentation so much. I just want to ask a question here. I know in regards to supportive excavation and foundation work, there are specific requirements that are determined by the engineer in terms of optical and vibration monitoring.
I'm going to
But
get to that.
yeah, I'm sure you will. But here it says the commissioner may make or require, but it doesn't say that it's required. Or am I missing something?
Okay, you're missing something. This is the issue with the existing buildings. Not the developers need to get in. That's governed under the building code. This is an administrative code provision for the existing building. It's a complementary code provision that says if we need to do observations of the adjacent building and the department needs to do them, we need to be able to get in. Not the developers' building code requirements that is statutory under chapter 33, under chapter 16 or chapter 18. This is if a landlord says that I don't want anybody going in because they're governed by a building code next door. We have an administrative code provision that allows us to do access. And sometimes that's necessary because what we do is we get reports of damage and then nobody allows us into the building.
Can I say something?
Go ahead.
I know people who have let developers in and
Yeah.
they take pictures. You know, in a brownstone, you might have a little crack here, a little crack here, and then they use that against the person to say the building was already damaged. That's why
Okay.
a lot of people is not letting people in.
Okay, I got it. And you're not wrong. I'm just saying what we have. These are the statutory requirements. I will tell you the merits of each of these as we go along. So
And
there's
Mr. Lynch, just bear, yeah, I was gonna say, bear in mind, the big thing that we have you here for tonight is that we do a lot of these as Landmark Preservation Commission applications. As a matter of fact, when you're finished, we're gonna have this specific thing come right up on that application. You're welcome to, sit in and listen. And what we've been getting are a number of LPC applications where they want to do work on their building,
yeah.
but the work, especially at the rear or on the sides, going into yards or into the, backyard or on side, will affect the buildings next door.
I
And
got it.
could be, and that's what we've been getting come more at this particular committee. So just bear that in mind. That's one of the problems that we're facing on this matter. Thank you. Go ahead, Mr. Lynch.
Mr. Gordon, I have to speak about this. What is being discussed is way over anything that the community board ever gets involved in. We don't know all of the machinations of whether the contractor gets into the apartment or the next building or not. That's beyond the community board. We are focused on what insurance does the developer and the house that is getting the work have to protect the adjacent houses.
I'm going to get to that.
That's the focus.
I'm going to get to that. Okay, so the reason why I'm showing you this is I just want to show you that there's statutory requirements for a number of things that gets overlooked. I'm not saying you're wrong. What I'm doing is I'm giving you an orientation of what's out there. It doesn't mean that we have to use it, but I want to show you what's available. Now, the reason why I'm giving you the information is you can tell if the information is there, you know that if somebody tells you that it doesn't exist, you will be able to say, wait, I thought I heard something at a meeting. Could I go back and check my notes? Or is this true or not true? It doesn't become anecdotal. It doesn't become rhetoric. What I'm going to show you is where in the code the different provisions are. And it doesn't matter whether you need them or not. What I hear all the time from the developers are they never got in, they never had access. We didn't have this, we didn't have that. What I usually do is I say, well, don't forget you're bound by the building code. You're also bound by the administrative code. And if you don't think you need to do this, let me remind you of these provisions. So I could tell you all about war stories and this and that and damage done to adjacent, but I don't think that's of much value. What I think a presentation of much more value is some of the statutory requirements that the developer is bound by. And that I want to go through today. Remember, these are minimum standards and the codes they're a little vague, but I'm going to focus on why you need to know that these things are there, because I do have them applied to jobs and why these things get away from us. It's a lot to take in, but seems you asked for the presentation. I think it's worthy of going through this stuff. Okay, so here's the other one. Here's the big one. This is the big one that a lot of people overlook. Owner's responsibility. Now, I'm not saying this is a good thing or a bad thing, but the owner's responsibility of a building, an existing building. All buildings and parts thereof and all structures shall be maintained in a safe condition. Okay, that's a tricky thing to figure out, whether the building's safe. So what happens is the developer thinks that he's got a robust building on the lot line, and that's the assumption. And the reality of the building on the lot line is it's a 150-year-old unreinforced masonry building, which is kind of ductile and it moves around a lot when you're doing construction next door to it. Okay, so what we tell the developer is, don't forget that building next door has to be maintained safe. And safe is not opinion-based. Safe means it has to have some minimum standards and requirements that you can reconcile against. And if you think an unsafe condition exists, you got to call it into the DOB. That's important. We remind everybody, if you think your building has been damaged, you got to call the DOB. Okay, that's important. Why? Because what ends up happening is people that get collaterally damaged, they don't call the DOB, and the conditions get so bad, by the time we get there, we can't intervene to stabilize the adjacent property. And I'll go through that in a little bit. So if your community, if your constituents are getting collateral damage from a developer and it's showing up in the building, make sure they know that they have to call it in. And you don't make an agreement with the developer next door not to call it in. The developers, they're only in and out for the length of the development. Once that job is done, they're off to the next project. Okay, but the neighbors have to live with the collateral damage and the insurance claims and the litigation and the damage to the building and his tenants complaining. All of that stuff goes with that. Okay, so that's kind of a good one. In 1855, an act respecting excavations in the city of New York, which was Manhattan, and the city of Brooklyn, which went over to Myrtle Avenue. This is directly from the state code for a building code of New York and Brooklyn, which was Manhattan and Brooklyn City, before the city consolidated, and Brooklyn City was Brooklyn City, Flatbush, Flatlands, Gravesend, and New Utrecht. That was Brooklyn City. So everything west of Myrtle Avenue. Whenever excavations hereafter commenced for a building or other purposes on any lot or piece of land in the city or county of New York and the city of Brooklyn shall be intended to be carried to a depth of more than 10 feet below, and there shall be any party or other or wholly or adjacent land and standing upon, if afforded necessary license. We've had statutes regarding collateral damage to neighboring properties since 1855 in Brooklyn. It says it in the code, and I put it there to realize that this thing has been around for collateral damage to adjacent buildings since 1855. It says here, preserve such walls from injury and so support the same by proper foundations that it shall remain in a stable as before the excavations were commenced. That's from 1855. So even in 1855, developers were mucking up existing buildings in Brooklyn, and they were doing it in Manhattan again. Okay, that code turns up verbatim up to 1968. It turned up in every building code that we ever published. 1855, 1869, 1879, 1888, 1899, 1901, 1916, 1922, 1936, 1968, and 2008. Verbatim. If you're going to do a development in Manhattan, New York City, don't screw up the neighbors. That's what that says. Okay, construction code sections. So we have stuff. There's three good things to think about now. We have statutes for the protection of the adjacent buildings. It's an absolute law. The problem is, how frail is the adjacent building on the lot line? That's complicated. It's complicated because these 19th century buildings, they're very ductile. They had codes that went with them, but they move around a lot. They move from season to season. And if you're doing a development, the building will move. It's part of the physics of how 19th century unreinforced masonry buildings do. So what we have is, I've given a quick list here. Tenant protection plans, additional information. All the drawings have to be complete and of sufficient quality. Interpretation, we can interpret all of the codes and everything liberally. Soils and foundations is in the building code. Structural design is in the building code. Compliance inspections are in the building code. Safeguards during construction are in the building code. So you are governed by the protective measures in our building code and our administrative code. These provisions absolutely exist. It's not anecdotal, it's not rhetoric, it's not opinions, they're absolutely in the code. The real problem is how much damage is going to occur to the neighboring property when you're doing the development. The developer has no interest in the adjacent property. There's no monetary return for it. It doesn't provide, spending money on the neighbor does not give him a new countertop. It does not give him bathrooms. It does not give him new, apartment layouts. You got to remember, the business plan for the development is inside the property line. However, there is a statutory obligation to protect the adjacent properties. The snag with the adjacent properties are, they're 150 years old. There's a lot of material degradation. They've been heavily used. There's very scant code how they were designed when they were built, and they're very ductile. So what happens is a relatively minor amount of activity on the construction side causes this disproportionate collateral damage to the adjacent building. Okay, so we're going to keep going now. That is the issue that you have. That is a section through an existing building with a vacant lot next door, where the excavation next door is deeper than the depth of the adjacent building. Everybody visualize that? What ends up happening is the new site undermines the adjacent building. That's a classic underpinning problem. The adjacent building is not as deep below the sidewalk as the new property. So what happens is they have to lengthen the depth of the foundation wall from the neighboring property. That's the issue in a nutshell. The buildings on the adjacent lot line, they are not as deep as the excavation site where they're putting the new building. It was in 1855, they had the same problem. You have existing buildings at 9 feet below grade. The new building needs to be 12 or 13 feet below grade. The problem is the neighbor needs to be extended down 4 feet. That's underpinning. Everybody visualize that? Okay. And so here's another one. So there's one, that's the building site. Development removes a building mid-block, exposing the side wall of an adjacent property, a stoop adjacent property. Everybody okay with that? Demolition is right there. You get the development site, you get the neighboring property. So here's the problem. The development site needs to excavate lower. And they undermine the foundation wall of the adjacent property. Now, I'm just showing you the illustration of why this occurs. There's a methodology not to do that. It's called underpinning. What you do is you lower the adjacent foundations by 4 feet every 8 feet. So you do 4 feet at a time, 4 feet, you skip 8 feet, you do 4 feet. There's a methodology to it. But the other one you got to watch is those high garages at the back of the sites. They are extremely frail because they generally are very, very high on the site, and you have a very deep excavation underneath them. So that's a classic Brooklyn development, right there. The developer has to lower the site to get the new building onto the site. Now he has to do it for a number of reasons. One, there's no stoop in buildings anymore, so it's not an up to parlor, down to basement. People do not want to carry babies and shopping and bicycles and groceries up 6 steps to get into a stoop. They want to walk in at grade and or wheelchair access or perambulators, any of these things. That's why the buildings are at grade now. There's not up to parlor, down to basement, where you actually get 2 entrances to the street. The problem is now the adjacent building is high on the site and the new building has to be low. If you've got an in at grade development, you need a minimum of 8-foot standing headroom in the cellar. And then you've got a foot for the floor. That makes it 9 feet. And then you've got about 3 feet for the foundation, 9, 10, 11, 12, and a foot for excavation, 13 feet. They are minimum of 13 feet below grade. The neighboring row house is at 9 feet below grade because there's a stoop row house in there, up to parlor, down to basement. What they did is they pulled the building up 4 feet out of the ground and gave a stoop to the parlor floor and then a walk down basement. It meant you got 2 entrances to the street level. The basement had its own entrance and the parlor floor had its own entrance, but it made it very difficult to get in and out of the buildings. You're up and down stairs all the time. And that's how these foundations are done, the underpinning. They lower the foundations of the adjacent buildings by blocks of concrete every 4 feet. Everybody okay with that? You can see the sketch. Doherty, can you see that sketch? It's okay? You can visualize it?
Oh, yeah. So I
Okay.
think what would be super helpful is for you to help us understand what we need to tell the people who come to us what they need to do
Okay.
to prevent the widowmaker, right?
Okay.
So you're getting to pre-construction surveys, but we need to go from there.
Right. I'm going to get there. First of all, I just want to go through the statutory requirements of what we have, because a lot of people don't understand that these things exist. Homeowners, community boards, what we do is we get a lot of this stuff after the damage occurs. We show everybody what the code provisions are. This is all about public safety. The building code and the administrative code, maintaining an adjacent building, is all about public safety. The developer does not want to be in the business of being in a financial or a business relationship with the neighboring property. It's just not where they need to be. Most of the foundation and excavation in Brooklyn has significantly improved since we started this work in 2005. We very rarely get foundation issues with Brooklyn anymore. Because why? Every 6 months we would campaign the designers, we would do site visits, we would go out, we would do industry outreach, and the building department invested a lot of money dealing with this issue with underpinning. So it's significantly improved now. When I started this 17 years ago, we were getting 2 to 3 incidents a month when I started this work. Now we get one about every one maybe once a month or whatever. And the designs have significantly improved, but the adjacent buildings themselves are quite frail and they do move around. When you transfer load from one foundation system to another, you get what's called foundation setting. So the buildings absolutely move. Even if the work is executed well, the adjacent buildings moved. It's called foundation setting, okay? So this is what we have, projection of adjoining property. This has been in the code since 1855. License to enter an adjoining property, physical examination. When permission to enter upon an adjacent has been obtained, a physical examination of such property shall be conducted by persons initiating the construction or demolition. So it's in the code. It's a statutory requirement that the developers must do an evaluation of the adjacent properties. Okay? They have to weatherproof them. They have to maintain the structural integrity of them. And they have to do all this type of work. The problem is we don't have a huge amount of statutory provisions to tell them what to do. We give them laws to say you have to comply. Why? Because there's multiple versions of the adjacent properties. This happens to be the 1938 building code and the 68 building code, but there's a 2008 version of this as well. Now, you can do underpinning and it can be done correctly, and you can raise a building and you can support a building. So there is nothing new under the sun about doing underpinning. They've been underpinning buildings since the Romans. Okay, so the work can be executed correctly. And I'll talk a little bit about that. And that just happens to be an example of one where the site extended underneath an unreinforced masonry building. By the way, do you think that's minimum standards? That's a luxury job where they could afford to brace up that unreinforced masonry building. It would have been a substantial amount of expense and effort. I'm flabbergasted that they did that, but that happened to be a cultural icon, that building. So it wasn't elective, it was a landmark building, so they were stuck with it. It would have been more inexpensive to take it down and put up a facsimile. It's safer as well to take it down and put up a facsimile. Okay, it's not correct, but it would have been safer because you would have got a new version of the old building. Now that's not great for 100 reasons, but it would have been safer. That's an amazing amount of work, and it would have been quite a structural and safety challenge to do that correctly. Okay, so we do have them where we lose buildings in Brooklyn. The ones we are particularly cautious of is the wood buildings, wood frame buildings. These are called noggin wall buildings, and they're quite prevalent in Brooklyn. They were outside the Brooklyn City Fire District. What happened was the state allowed tenement buildings and 1- and 2-family buildings to be built out of wood. But inside Brooklyn City, where it was a fire district, early, they said you're not allowed to build these things out of wood. So what we see is a tenement building, an no-law tenement, inside Brooklyn City, made out of brick, in Manhattan, made out of brick, outside of Brooklyn City, where it was Flatlands, Flatbush, New Utrecht, and Gravesend. The exact same building was made out of wood. So those wood buildings are really quite frail, and they're quite numerous in Brooklyn. And we're watching them closely right now. This one actually got away from the developer and we lost it. Screwed up design, the whole works. It didn't impact anybody but the developer. The building was empty at the time, but they are frail. Wood frame buildings can be frail when you're doing work next door to them. So this was out in Queens, underpinning under a 1-story garage. They're very frail. So they lose the walls from this. And this was quite prevalent when we started this work in 2005. We don't get a lot of this anymore. Okay, where a big chunk of the rear walls of these 1-story garages will be lost. Underpinning problems. Why? The mechanics and the engineering of underpinning is challenging. There's a lot of, basically, you got to keep the existing building in equilibrium. The vertical loads have to be in equilibrium. The horizontal loads have to be in equilibrium. And any rotational loads on a wall has to be in equilibrium. And it's usually overlooked by the engineers, the rotational load from the soil. So they build this foundation wall and the soil actually imposes a lateral load onto the pin and it knocks the pin into the site. So I'll go through that in a minute. This was one I did this myself. This was a Brooklyn job where we lost an underpinning job under a 1-story garage. There was a guy killed in this one. So it does happen, but it's rare now. But underpinning, a big problem. Okay, it has to be done properly and it has to be designed properly. The other issue is you have to be very vigilant of what you're underpinning. So I want to go back here to the existing buildings. Existing buildings have to be evaluated correctly. And the engineers for the developers have to be afforded the ability to do an evaluation. What happens is if they don't do the evaluation, they make some crazy assumptions to get them through so they can start work on their own site. What ends up happening is not having evaluated the adjacent buildings. It turns out the adjacent buildings were quite frail. And then they made an assumption about underpinning them, lowering the foundation, and the assumption was wrong. So nobody was a beneficiary here. The adjacent property, they lost a whole load of pieces of buildings that they had stuff in. There was a guy who didn't make it out of the construction site, and then we ended up backfilling the site. Look, development has merit. You get larger rent rolls, you get new construction, you get a new tax base for the property, you get a safer fire resistant building. So in some senses, and also you can, sometimes it gets rid of an unsafe building in the middle of a block where the building itself is unsafe. Now, I'm not saying that's the only merit for doing the development, but there is merits for the development. It also puts people to work. There's a lot of people on these construction sites that are working, and then you end up with new housing as well. So it's not like it's not going to happen. And our New York City housing is aging, and it needs to be taken care of. And that's prohibitive for some people of limited means. And then you do get more housing on a block. You get denser housing, you get safer housing. But the problem is trying to get the job into the site can cause a lot of trouble. And usually it's the foundations. Once the buildings are out of the foundation stage, the site is made safe. The risk to the site is diminished greatly. Okay? So the new buildings are dictated by codes, but the existing buildings on the adjacent site, the codes that govern them are very scant. And that leaves a lot of interpretation for the engineers when they're doing the stabilization and the foundations. So the new buildings coming up out of the site, they are governed by this enormous, fabulous code that we've had since 2008. The evaluation for the adjacent buildings next door, the engineers need to have knowledge of how those unreinforced masonry buildings were put together. And the other issue is they have to be able to evaluate them to determine, is it suitable to do the work next door to them? And that's the first question I asked the architects. I said, before you said to everybody, what a fabulous idea to dig out a 20-foot hole on this construction site, did you think it was safe to do that with the adjacent property? And many times they said, yes, we did the evaluation. We've entered into a license agreement with the neighbor. We've told them that we're going to get some collateral damage. The repairs will be repaired. And we'll do this, that, and the other to restore the safety of the building. It happens a lot. It happens more now than it used to 10 years ago, where the neighbors and the developers end up in a license agreement. Okay? So they get access through a license agreement. They get to underpin through a license agreement. Collateral damage is covered in a license agreement. But believe me, the problem is, you know, you have to get these things in motion before the construction starts. And those license agreements can be time consuming. And we don't cover them in our building code. Okay, and here's another one of these unsafe conditions where the site was being excavated. This actually is a Brooklyn job, and we lost somebody on this one, which was a know-nothing concrete block storehouse at the back of the site. And they lost a wall underneath that, and there was a guy on the site. So, you know, it's in nobody's interest to get injuries or collateral damage. It's just not where everybody wants to be. Nobody's the beneficiary of this. It's not what we want. People get hurt, the development gets shut down, there's vacates in the neighboring property, there's insurance cases, there's litigation, there's prosecutions, there's stop work orders. It's not where anybody needs to be. Okay, so we have audit sheets. We write down audit sheets. We give our plan examiners audit sheets. So we have sheets that list all the technical requirements that are required to get a job through plan exam. It's complicated because you need to know what's going on the lot line with the adjacent building. Is it a row house? Is it a no-law tenement? Is it a wood frame tenement? Is it a taxpayer? Is it a 6-story new law tenement? Is it a commercial building? Is it a firehouse? Is it a school building? Is it one of these things? So there's a lot of variation on the construction site. So yeah, you need to have some knowledge of that. So we have lists of questions that we ask developers and their designers. So who's responsible for an underpinning job? The department, we have a piece of it. The architect for the new building, they have a piece of it. The engineer, the contractor, and the owner. The owner and the engineer carry the bulk of this work. Okay, so if there's collateral damage and there's underpinning and there's supportive excavation for a neighbor to get a new building in the middle of a block with lot line construction, the bulk of the liability for that, for the work, is on the owner, the developer, and the engineer. This is an engineering issue. Okay? Construction underway under permit. So we have specifications, duties. Chapter 16, structural design. analysis. So we've got specifications. We tell the engineers, don't forget, you got to do this, that, and the other, and you got to do it properly, and you got to use your calculators, and you got to use your computers, and you got to do this, and you got to do that. You know what the building they're going to get right? They're going to get the new building right. The problem is applying that engineering theory to an existing 19th century building. It's a challenge. Most of the engineers, it's difficult to figure out how those buildings were built and if there was alterations made to them and how frail they are and how well maintained they are. Everybody okay with that?
Good.
There's design. It's in the code. Underpinning and support of adjacent properties. This is in the 2014 code. It's under chapter 18. Where the protection and support of a structure or property adjacent to an excavation, an engineer, not an architect, an engineer shall prepare a pre-construction report summarizing the condition of the structure or property. I think, Doherty, you asked me about that, right? The pre-construction report. There it is. Chapter 18, 14.1. The snag is that construction report doesn't make it to the DOB. The pre-construction report shall be prepared based on the examination of the structure or property, the review of available documents, and if necessary, excavation of test pits. The engineer shall determine the requirements for underpinning and other protection and prepare the site for structure-specific plans, including details and sequence of work for submission to community. I wrote that provision when I went into the 08 code. Myself and a couple of guys wrote that provision. We had engineer put in there. Nobody spotted it when we wrote the code. It's rare to call out an engineer in the code because it can be any licensed professional. But in this particular instance, the pre-construction reports are worthy. That is something you can ask the developer for. Have you a pre-construction report of the adjacent property? And say, look, we're here to help. Everybody wants to move forward. You got a permit, you're going to go to work. But let's make sure you don't screw up the adjacent properties. Let's see what you know about them before you start work. And then the first thing anybody's going to say is, I wasn't allowed in, which half the time is not quite true. But that's the stock line. That's why I showed you the provision for access. The reason why the guy said they screw up the building is because they could not get access to do the evaluation. And it's not true. So you have to be careful of that. Okay, that's a good provision. It's a strong provision. It puts the duty for the evaluation of the adjacent property squarely in the hands of the developer. But it does require cooperation from the neighbor. Here's another one. Compliance inspections. Where construction operations have potential to affect the structural condition or occupancy of a structure or subject structure, the structural stability of the structure subject to special inspections in accordance. It's a little blurby, but there is a requirement for the developer to do observations during construction. Not turn up after the damage has occurred. But there is a code provision requiring the developer to have a specialty person check the work and make sure there's no collateral damage. And if there is collateral damage, stop the work before it gets out of hand. Adjoining walls. Chapter 33. Chapter 33, this is an awful place to have these provisions. It's actually the construction where this is for site safety during construction. This is, you know what this is, this provision? If you're in construction and you're reading this provision, it's almost too late. It should have been part of the due diligence that went into the design and the evaluations of the adjacent building. Any construction or demolition operation exposes or breaches an adjoining wall, including a load-bearing and non-load-bearing wall, as well as a party wall. The person causing the construction or demolition shall, at his or her own expense, maintain the structural integrity of such walls. There it is. There's another duty statement for developers to maintain the structural integrity of the adjacent building. The snag with that provision is you're already in construction when you kick that one in chapter 33. They're already in construction when they read that. Okay. And there's some bracing that we put on a wall not that long ago on a job in Brooklyn. Look, I gave you a summary of some of the provisions required for existing buildings. I didn't go through a huge amount of stuff because it's late. It's a 1-hour presentation. It's difficult to present this stuff to non-technical people. That doesn't mean you won't understand it. But late in the day to do a 1-hour presentation that's highly technical about a special project, I'm giving you an orientation on it. What I'd like you to consider is the following. 1, note that there is code provisions that govern the work. 2, the building department is full of experts, but we don't like turning up on a job when there's a lot of damage occurred already. 3, make sure that the neighbor affords access because it's strategic for developers saying they never got access to the buildings. Now, there's 100 reasons why they don't get access. There's a tenant in the way. The guys are away. The landlord's away. This, that, and the other. It's true, and I get it, but it's a problem because if you don't afford access to do an evaluation, regardless of whether there's cracks there or there's not cracks there, the problem is it's difficult to leverage our code on enforcement saying you were supposed to do a pre-construction site, you missed this condition over there and it got messed up during construction. And then the developer turns around and says, I never got in. So that's an issue. I'm not saying it's the right issue. And then the other issue is 19th century unreinforced masonry buildings are difficult to evaluate. They're very ductile. They move around. Why do they move around? Bricks and wood frame construction are based around lime-based mortar and soft joints. They're very ductile. So the buildings are plastic, which means they do move. They're not rigid like a large steel framed or concrete framed buildings. Unreinforced masonry buildings, which are really row houses, they're extremely ductile and they move. They're strong, but they do move. And the problem when they move is they crack all the finishes on the inside of the building. Okay? So, and then you got 150-year-old finishes. A lot of the stuff performs badly when it gets underpinned. And if they underpin a wall, the wall has to, by physics and by the nature of physics, it will move. It has to transfer the load from one system to another system. So that's a 1-hour presentation, orientation on underpinning. What I offer you is thought process and come back and do a targeted conversation about things specifically you want me to talk about, which is the landmarks preservation requirements for local for TPPN 10 of 88, which has some statutory requirements for moving and observations, and some other technical specifications for how much a building is allowed to move or what happens when an adjacent building moves. I think it's a lot to do in one meeting, but I'm willing to do it in a second meeting when you have time to digest what we spoke about, if that's correct, Carl.
Yes, thank you, Mr. Lynch. Exactly. We'll consult with Caroline Church, perhaps to get you for a second, because we do want to, our focus is mainly on the landmark LPC applications. Again, we're going to have one coming up and you're welcome to sit in and watch and listen and see how we do on it. But it is a key thing because that's one of the things that we've been getting more recently are make sure that the owners, the applicants are carrying out their duty, as you're saying, and at the same time that the neighbors are protected by the codes from what you've laid out. So right. I think those are things that are most helpful. And I think, yes, I think we should have probably a specific landmark preservation, I guess another lecture or another talk, and perhaps Caroline Church can set up another one with you for a future, one of our future meetings, so we can really focus on that and know how to deal with those those problems as they come up. We do get neighbors coming in to saying, oh, his extension is going to knock my building, or affect my building. So we need to, that will really help us a lot. I guess we have a few minutes for questions, but we do want to get into the meeting. We'll start mainly with Daughtry because she's really the expert. And Daughtry, you have any other remaining questions or things that Tim Lynch should answer or answer?
Two questions up, Carlton. Judy and Ernest have questions up.
Yeah, I will just say
Okay.
quickly before that is that this has been a super informative presentation, even for somebody who's in the field like myself. I will offer to condense some of what you have shared with us into a one-pager for our committee. And I'm asking perhaps if I can talk to you directly if I have any questions.
Absolutely. And I'm offering another meeting.
Yes, of course. Thank you.
Can you hear me, Carlton?
Okay, thanks. Okay, yes, we can, again, just about hear you, Ernest. Go ahead.
This one, okay, let me turn it up. So this was a very good presentation. This is something that Ree from Clinton Hill, Fort Greene wanted to bring to the attention of this of the Land Use Committee. Fort Greene, Clinton Hill has been plagued by these structural damages. Just last week, reapproved a LPG application for 370 Adelphi Street. I'm walking past that building, and guess what? The building at 368, the adjacent neighbor, is being damaged. And there was a DOB building inspector there to try to address the issue. Again, something that reapproved, 370 Adelphi Street in the Fort Greene Historic District is now involved in an adjacent damage to 368. So this has been a problem. So they basically are undermining your historic district, and the other problem is that given the hyper gentrification and with people buying houses, developers buying these houses and trying to enlarge them, it has compounded the problem. But it's something that, again, we wanted to bring to the attention, and I appreciate Mr. Lynch's presentation because he's on point. The question is, we never tell the applicant to make sure that the adjoining neighbor comes to the landmark meeting, and we never insist that they draw up a license agreement before they do anything else. They can gain access if they're told to get the license. They can. And Mr. Lynch acknowledged that. They can't say no. They will have to demonstrate that they sent notice, at least 2 notices to gain access, and to get the attorney. But they have to be informed. I would argue that we should be informing the applicants that coming for LPC for application to ensure that the neighbors be present when we review the application and discuss having a license agreement, something that the building department can then enforce.
All right, Ernest, let me thank you. I think it's something we can look, that's part of what we should be looking into. And I guess you should let Caroline know about that 370, 368 Adelphi. Maybe that's something that the board office can at least make an inquiry on. Judy?
Hey,
Yeah, I want to go over to Judy now.
yeah, I wanted to ask Tim Lynch this question. Once access is granted and the adjacent property owner is cooperating and providing access because he or she understands it's in her best interest, how is the resulting inspection supposed to be documented? Is a formula for that, a specific form? Is it just a narrative? Are there video?
I can help a little with that, Ms. Donovan. There are minimum standards of items to be reviewed. It turns up in a photo documentation, existing conditions, and interpretations.
Or is that a page in the code somewhere?
It's not a rule and it's not in the code. It's in a, we have some, what we did is we sort of came to an industry agreement in what should be in these minimum standard specifications. It's covered in a range of different documents. I will help you with the specifications that go into those reports. The snag with the reports is they're not submitted to DOB, but they are available after the engineering evaluations. They're not one-pagers. They used to be photo documentation, and then there was an evaluation that went in, and then an interpretation of the performance of the building.
Okay.
Okay, well, thank you. I want to move on to the our actual Landmark Preservation Commission application.
Excuse me,
So if we-
Carlton.
We
You
need
do
to
have
do
one
that.
more question from Esther Mount.
Oh,
You're on mute.
Does
Oh,
DOB at any point in the permitting process ensure that license agreements are in place?
No, the problem with the DOB's license is we don't have statutory governance over license agreements.
The other thing is, what would you do if you had a brownstone and the person next door to you was doing underpinning? Before you let them in your house to do their own engineering inspection, wouldn't you have your own engineering person come in
Absolutely.
to protect
Absolutely.
yourself? This
Yeah,
is the kind of information that we want the community to know.
Yeah, what normally happens is the license agreement, and I'm just speaking off the top of my head, this is nothing in the building code. License agreements usually cover, they cover, whoever the owner's advocate is, it usually covers their fees. And it usually allows for an engineer working on behalf of the owner of the adjacent property that's mutually acceptable to both parties. So yes, Ms. Blood, the neighbor normally is represented by an engineer, but it has to be somebody that's a structural engineer, not an electrical or mechanical engineer. So somebody who has some expertise in existing buildings, and it's usually a licensed engineer. And it's usually, that service is usually compensated for in the license agreement, and it goes into part of the license agreement that the engineer working for the neighbor. And usually what happens is, I have a job in the West Village right now where the neighbors, the two engineers are working together to make sure that the adjacent property is not damaged, and the relationship is quite strong. Look, the neighbor is going to get the permit. They're going to get it. The problem is that you can't be working you're bound at the hip with the development until you're out of the ground. Once your foundations are done, the risk to the site is minimal. So unfortunately, with the way we are in New York City with lot line construction, the developments are going to happen in these mid blocks for 100 reasons. So it pays to make sure that there's some cooperation between the two parties.
So what I'm hearing is that the steps we need to take to protect our homes is to first get a license agreement. Am I correct?
We don't govern the license agreement, but that is normally the
I know you don't govern it. I think we need advice on what community members can do. Like if for example, was going through this, what would you do to protect yourself? We need to follow those steps to protect our community, because it's a lot of damage happening here.
Right. The license agreement usually states, if we screw you up, we're going to fix everything up, or we're going to compensate you if we have to move your tenants out. We pay for the attorneys, we pay for the engineers. That's what I'm used to seeing in license agreements. We're not the required, we don't put the license agreement together, but that seems to be the vehicle of choice for doing this. Otherwise, you're in some relationship with the developer next door, and I'm not too sure. Most developers are okay. They say, fine, we'll sort it out. But some of them say, yeah, I don't want to talk to this guy next door. And a license agreement sort of helps move that along. We're not advocating for license agreement because it's not in our governance, but we do see a lot of them that's where they turn up. If you need to work a relationship in between the two properties, we see it a lot in license agreements. I'm not saying it's the only way, but we do see it a lot in license agreements.
Does DOB keep track of repeat offenders?
Yes,
Okay.
and we
Just- Okay, I gotta move on. Well, we
Thank
have
you.
to move on. Yeah, we have to move on because we still have quite a few things to do. And in fact, the
But
next
Carlton,
application,
Under Carlton, before you go to an application, you have to open this portion of the meeting up to the general public as per what Carol Ann Church presented at the beginning of the meeting. This is exactly what Carol Ann Church was talking about.
Okay, I'm going to bow out.
yes, well, I just want to get on the topic so we can move towards the topic.
Thank you, Mr.
So-
Lynch, for your, I'm sorry, Carlton, to interrupt, but Mr. Lynch, before
Yeah.
you go, I just want to say thank you for
Yes.
the time. And we really appreciate all of your technical expertise and you're willing to share it with us.
I'll be glad
Yes,
to come
thank you
back.
very much.
Bye.
And we'll ask Carolyn Church to get back to you, and maybe we'll try to set up a mutually agreeable time to concentrate on an LPC and a landmark preservation matters. All right, well, first what I'll do is again, as usual, I'll open, I'll present the first part, just the application itself, and then we'll ask for the public comments, and then we'll go on to the actual presentation. So we do have an LPC application for 253 Carlton Avenue, no relation, which is in the Fort Greene Historic District. Basically, it was a 3-family residence, which now they're looking to do it as a 1-family residence. And there will be work at the rear on it as well. It will be a 2-story extension. And there'll be, what else do we have? Yes, there'll be an existing, like I said, they want to do it, it'll be flush with the existing extension. And 4 violations, presumably DOB violations, will be removed as a result of the work that's going to be done. First, I'll just ask, is there anybody in the public that wishes to comment at 250 the application for 253 Carlton Avenue in Fort Greene?
Mr. Gordon, that's not what I was talking about. The public needed an opportunity to ask Mr. Tim whatever questions they needed to have answered about his presentation, not about this application.
Well,
What
that's
happens afterwards?
the lecture that he's given to us is a lecture for our benefit.
Caroline, could you please weigh in on this so we can get this right?
The comment is really for matters that we're going to take action on. So there is some leeway on non-actionable items.
So I'm unclear. You said that the controller said that the public needs to be able to comment on issues that are being discussed at the community meetings. Now you're saying it's only those actions that require a vote, because that's what we've been doing all along.
So if we're up for discussion on this, so what is required? Members of the public should always have an opportunity to voice comment on agenda items.
Right.
However, compliance is really specific on matters that are actionable. That the public should have a formal period to comment before we take action, and that it needed to be stated on our agenda.
Well, Tim Lynch has left this meeting, so he's
So-
not.
Yeah, so moot point, right?
And the point is that, when we have these presentation lectures, it's really not an action. We're doing this for our information. Anybody else who's listening is, glad we can listen. And sometimes if we had time, we could actually even open up for public, but we do have a lot right now. His lectures are long, but very useful. So
Caroline,
right now, we're going to,
You have
Yeah,
to share the
that was the
controller's letter with the landmarks committee so we could understand exactly what the controller said. Because what you explained earlier versus what just happened, I interpret it as totally different.
Mr. Du, if I may,
Anything?
this is an action item. I don't think that we should go back and forth right now. I think the action item is to get clarity on what the new rule means for our meetings.
Right now, this is a way,
The
Mr. Richards is-
action is, the rule is on actionable items, we must formally request public comment before taking a vote, and it's preferred that it is stated on the agenda. The informational presentation is optional if time is allotted for public comment. It would be great if we can do that. However, the matter of compliance is on actionable items.
So can we
Okay,
move on
let me
to
ask-
item number 7?
Yes, because it is now a moot point since Mr. Lynch has left.
That is correct. So I'd like to be able to go on at this time. I've already opened up the matter for 253 Carlton Avenue. So now, according to the controller's requirement, I'm now asking if the public has any comment upon this, item at 253 Carlton Avenue. Hearing none, I will now ask the applicant for 253 Carlton Avenue to proceed.
I am just opening up. Hi, I'm Jim Hill from Urban Pioneering Architecture, the architect for 253 Carlton. I assume at this point I should be able to share my screen and begin the presentation.
Okay, Taya Mueller, you help him to share his screen?
Can you all see my screen now?
Yes.
Yes,
Okay,
go ahead.
great. So I'm going to just correct one minor bit of the description that you gave, Carlton, that
Go ahead.
the violations are not DOB violations. They are landmarks violations, work without a permit. I'll touch on them in a minute. Going to what I thought was the premise of the previous presentation for community involvement. We did speak with Rosario Sinisi, the president of Citizens for the Responsible Neighborhood Planning of Clinton Hill and Fort Greene. She shared the presentation with the Society for Clinton Hill and Fort Greene Association LPC reps. I did speak with Ms. Sinisi after she reviewed it, and she felt that, and I believe she's dialed in here, she can correct me if I'm wrong, felt that it didn't need further support. She had no adverse comments about it. So getting into, so here we are, the existing building, according to the landmarks report, 253, which is this one here, retains much of its original detail, whereas the only kind of its sister building, come on, computer, there we go, 255 to its right, has some additional details that were added. So the actual conditions, original conditions were somewhere in between. However, the landmarks violations that have been discussed are not part of this presentation. The owners have put money into escrow accounts to address all of these items on a staff level, and they will be taken care of as a separate application that will be carried out while work is underway here, and will be a requirement for sign off from landmarks on all of the work. So, so the main reason we are here is because of the extension in the rear and the inability of the staff to approve it at this staff level, primarily because of their kind of set rules and criteria that we don't meet for staff level approval. So the first kind of big one is, can it be seen from the street? Here's the block plan. You can see we are here. This is our extension. There is no view corridor throughout. These are pictures of the existing extension. Not a very attractive piece of architecture at all. So we will be removing that and replacing it with something similar in scale, but we feel much more attractive. One of the big criteria for approving this at staff level is, are there more than 50% of the other buildings in this block that have extensions? You can see on here that while there are not 50% overall, on our south half of the block, about 50% are, but we don't meet that criteria. So automatically it means that we do have to go through the commissioners. We go down. So here you can see the existing extension, 1 story on the left. You can see the adjacent buildings on either side. On the left side, on the north, extends past our main building. So you can see on the right where we have the proposed, the 1-story extension matches the existing extension's depth. The second story steps back to align with the existing building to the north. And you can see we have a gap between the side of our building and I don't know if you call it an extension, but a larger part of the building that has a side court to the south. Here are other examples of those extensions. In each of these cases, these are all existing extensions that we were able to photograph just on the Adelphi side of our half of the block, with one immediately down on the side in Carlton. You can see in the middle, 244 Adelphi is one that's been recently approved, has not yet been constructed. And I'm going to zoom in on that one just because it's a very good recent example, similar in scope to ours, except they are 2 stories high at the full depth, and then a 3rd story at a recessed depth, and then their top windows, top floor lines. So there's, while it has been approved at a larger scale, and it's a pretty similar approach. Rear elevations, you can see the existing on the left, the proposed on the right. Other conditions for approval are the top row of windows. You can see that on the top, we are maintaining all the existing masonry opening widths, removing the bars. Only one of those windows is changing. It goes to a door. So we're just lowering the sill within the same opening. The proposed extension at the bottom projects out further than the second story, which is actually considered the first floor. It is stucco clad, white stucco, and steel and glass doors throughout. The sections showing the existing building and the existing extension with the adjacent building to the north, the larger building in the background. You can see here it's specific to Mr. Lynch's proposal. Actually, we have kind of a funny little extension to the cellar that was already part of the original build. And our extension, the existing extension here, the proposed extension here, you can see we're maintaining that. So we are not proposing any conditions which require underpinning of the adjacent structure. Here's more of a side-by-side comparison. And
you believe that the work you're going to do will not affect or interfere with the neighboring buildings?
Correct, correct. No, there's no addition on top of the existing building. It's all in the back where there is none. Existing and proposed, existing left on the right, proposed to the right. So you can see we've got basically a crawl space on the right underneath our extension so that we can minimize foundation depth. Again, existing proposed, the first floor, which is at ground level. They're basically, first floor here is what most would really kind of consider a basement or garden level because there is no stoop on this building. So the old kind of rickety extension in the back gets pulled off, we build a new one, and then we have bedrooms and stuff downstairs. Up on the second floor, which in traditional brownstone would feel kind of more like the brownstone, I mean, like the parlor, kitchen in the back, terrace on top of the setback of the roof. Third floor, bedrooms, and that's really it.
We'll be using new materials, obviously, but will materials blend in with, still with the, I guess, with neighboring buildings and the community?
I'm sorry, it's a little hard to hear you.
Well, I'm just trying to think the materials that you'll be using to fit, for the extension.
So if we go to the rear elevation, the top floor, the existing brick, don't have a good picture here, but the existing brick had been painted. That paint will be removed and restored. The brick will be restored, and then the extension will be stucco. Will be a white stucco.
Okay. So you're keeping as much of the original as possible.
Right.
Okay. Any other questions from committee?
Yeah, I have a question, Carlton. Why are we reviewing this?
Yeah.
I made a site visit to that location. I walked around the block. I cannot see anything. You can't see extensions on Carlton or on Adelphi Street. It is solid. I mean, you cannot see anything from the back. So what are we talking about materials? We can't see it.
Even with that, they came to us, some people will see it, and
No.
LPC required it.
You physically cannot see it, Carlton. Physically. Make a site visit.
Apparently,
Yes.
apparently Landmarks is requiring us to review this. So I appreciate that you can't see it, but we have to actually review it.
Review what? What are you gonna make you're gonna talk about materials that you can't see?
Ernest, I think it has to,
Well, this is, okay, it's been required. Judy, what's your question?
I was answering Ernest's question. I think it has to do with the amount of existing material being removed and replaced with glass.
Can I speak to this?
You physically cannot see it. That's the point. John Dew is correct. Why are we reviewing something that we cannot comment on?
Oh, well, read the landmarks law, Ernest. It has to do with the historical integrity of the.
He's talking about the donut. You can't even see the donut.
All right. Okay, we have that. Are there any other questions on this matter? Any other points to be
I'd
made?
like to make a motion to approve. Like Mr. Hill
Okay.
said, Fort Greene Society, the community does not have any objection. All the stakeholders in this has no objection to this project. So I'll make a motion to approve.
I'll second.
You have a second?
I'll second.
Okay. Second by Hazra Ali. Any comments or questions on the motion?
May I just ask, the architect actually volunteered to respond to the question that was put forward about why we're reviewing. I don't know, Mr. Hill, if you want to speak to that, but I'd like to give you a moment.
I'm happy to. I don't feel compelled to, but if people are interested, the reason given me by the staffer was that staff level has a specific set of criteria that they are allowed to approve. And this does not meet those criteria because of some very specific items, things like on the either side of the doors in the rear, the brick piers, if they are less than 24 inches, I believe, then Landmarks isn't allowed to, or the staffers aren't allowed to approve them. Most specifically, it had to do with the 50% of the block. If we could have easily modified the rear, the design and in any way to meet all the requirements, but because the existing buildings, there are not 50% of which that have rear extensions already, that alone means that it goes to commissioner level and thereby you.
Thank you, Mr. Hill. If there are no other comments or questions, we'll do a roll. I'm actually able to see for the first time all the people who are, all our members. So I'll start with Ernest Augustus. Give me yes or no or extension on the motion.
I'm going to abstain on this, Carlton. Abstain.
Okay. Judy Stanton?
No.
No. Hajra Ali?
Yes.
Yes. Esther Blunt?
Yes.
Okay. John Doe?
Yes.
Okay. Brian Howard?
Yes.
Okay. Let's see, we have Alan Washington making a guest appearance. Alan?
Yes.
Okay. Daughtry?
Yes.
And me also, yes. So we have seven yes, one abstention, one no. So the motion passes.
Thank you
Thank you very much, Mr. Hill.
Thank you all.
Okay. And the next one, 43 Pierpont, I've been informed has been resolved at staff level. Am I correct on that, Caroline? Yes. Okay, so that takes care of our Landmark Preservation Commission applications at this time. Next thing is Chair's report. I have a couple of things just to knock over to you. I'm a member of also a number of things, including the Electric Railroaders Association. And they put on their newsletter the information. Some of you may have heard about it, but I will still just go through it as quickly as I can. And I'm taking little excerpts of it. I think this is something that's of interest, I think, to the committee. This was, and we discussed, I think, this in previously, the MTA it's the elevate transit zoning for accessibility. So that did get passed by through the approval by the mayor, the city council, and the MTA have all approved it. So there will be, it'll help with the people who have accessible, under the, action for accessible, for disabilities, and will help in getting the zoning approval so that stations will be built on the subway and the Long Island Railroad and the Metro North and even the Staten Island Rapid Transit, so that there will be accessible stations throughout the boroughs, and easements will be certified, will be able to be obtained by the MTA to allow for these, for work to be done, to allow for access. And there will also be transit improvement bonus that will also be allowed. There will be directly funding and building new transit station access improvements, such as elevators and otherwise circulation improvements at already accessible stations in exchange for floor area bonuses up to 20%. So that's something that has been approved. It's now part of the, I guess, the bureaucracy, and that should, is something I thought you would like to know. Another thing I thought you might like to know, some of you may have heard it, is that since it's sort of related in transit, is that the Long Island Railroad has as of I think last week, has run a test train through the 63rd Street Tunnel, which has terminated at Grand Central Terminal. So they say within a year, there'll be Long Island Railroad, I would say, service at Grand Central Terminal. And finally, just out of, some of you may find this of interest. Monopoly, the famous real estate game, has now a Brooklyn edition. So if you buy it, you can buy the deeds to the Brooklyn Bridge. You can buy the deeds to Junior's Restaurant. You can buy the deed to the DeKalb Avenue subway station and other places throughout Brooklyn. So you can pick it up at Junior's as a gift for yourself or just for the fun of it, for somebody else. But there is now a Brooklyn edition for the Monopoly game available. Next is other business.
Mr. Gordon,
We don't have it. Yes, we don't have it. Other business, go ahead.
Mr. Gordon, you did
Yes.
explain, you explained the bonus that developers are allowed of 20% in order to create access to the subway stations. We are dealing with this in the Transportation Committee because access to all of the stations has been a priority for Community Board 2 since the 2004 upzoning of downtown Brooklyn, where the city and state and whoever needed to agreed that all of the stations will be made ADA accessible. And from 2004 until today, there has been no ADA stations made accessible in downtown Brooklyn. And in the 5-year plan, I think I heard that Borough Hall might be included. The Transit Authority has a formula that essentially says that every third station, they are going to look to be made ADA compliant. We should note that New York City has the lowest accessibility in the country. We're in about 28% of our stations are ADA accessible, whereas the nationwide average for a mass transit system is in the 70s or 80%. So we have a long way to go. We have been able to get ADA access to the mezzanine in 2 stations using what the city council just approved without the city council's approval. So we have not at all been satisfied with the city council's approach to ADA accessibility. I will tell you, it is not defined. We are expecting, if they're going to do this, that it should apply to all buildings, not just buildings that have the accessibility close to a station, because all of those buildings have been taken up in downtown Brooklyn for the most part. So we're not going to have an opportunity to gain that 20% access. We want all buildings, if this is going to happen, to contribute to ADA access in downtown Brooklyn. So we have let Senator Kavanaugh and a couple of others understand that this is something that the community board has been doing since 2004. Of course, it hasn't been reported because all of this happened under the previous board office administration, and you never got management reports. So this stuff is now being discussed. But we do have the Hoyt-Schermerhorn Street station and I think it's the R station at Duffield Street. There is an elevator in the building that takes you down to the mezzanine. But the MTA, this has been for 10 years, the MTA has yet to include the elevator from the mezzanine down to the platform. So that's what all of the city council is talking about. Of course, they did not consult with Community Board 2 in advance to understand what we had done and what we need to have done. So this law doesn't actually work as best as it could for Community District 2.
Yeah, I think the R train one, it goes down into the other end of the J Street Metrotech station. And it is a sort of like a half elevator, which is, I guess half an elevator is better than none, but it does go from the street at, I think right at Duffield, right on Willoughby actually, and down to the mezzanine level. And then from the mezzanine level, you'll have to walk down the steps.
Yeah.
Are there any other business?
You're correct about that. Mr. Howell just put in the J Street
Yeah.
elevator. The J Street elevator, for information, of the Landmarks and Land Use Committee
Yeah,
does not allow any social distancing. It's a very small elevator, and we had requested via transportation to have another elevator installed at the other end so that it would be appropriately accommodating for all of the additional traffic that's happened downtown Brooklyn. And of course, that did not happen either. So these are items, Mr. Gordon, that we need to be very much more proactive on in the Landmarks and Land Use Committee and coordinate more with the Transportation and Public Safety Committee so that we can all be on the same page with the same information.
all right. If there any other business from anybody else,
Mr.
any other
Gordon,
member, any other?
This is
Yes,
Esther.
Esther. Yes, Esther.
Are we supposed to be taking some sort of action on this dog run? Tanya sent out something about.
Actually, I'm going to move on to that right
Okay,
now.
I'm sorry.
Yeah, because that's going to be under, right now, under community forum. No, we're not having, well, if we do have an action, let's see if we do want to have an action. First, we want to hear, if there's no other business, I am now moving into we're now moving into community forum. I received, and I think all committee members have received a communication from Caroline Church concerning well, let's say, Raoul Rothblatt, concerning a possibility of a dog run over the Abolitionist Park or Abolitionist Square. And he's concerned about that, and he's asked to address the committee on this. And he's asked the committee to see, if we should even send a letter supporting what he's going to ask for. So what we'll do is we'll ask Mr. Rothblatt. I'll allow you 3 minutes to make your presentation, Mr. Rothblatt, and we'll discuss the matter if need be. Is Raoul Rothblatt there?
Mr. Gordon, this is Taya Miller. Mr.
Yes, hi.
Rothblatt does not, hello, Mr. Rothblatt doesn't appear to be on the call today, but he actually presented to the Cultural Affairs Committee at their meeting yesterday. The committee did put forth a motion to recommend a letter of protest to be voted on by the general board at the December 8th meeting.
All right, thank you. All right, so we'll leave it at that for this time. I think it's being appropriately handled. Are there any other folks from the community, not board members, not committee members, but anybody else who wishes to address an issue?
Vice Chair Karstoffen has her hand up.
Sorry, I just wanted to say that in regards to the dog run issue at Abolitionist Park, that as a professional, I think that the issue has been raised and it's a legitimate one that can easily be accommodated in the design. So I just wanted to say that I support the letter of protest.
Can I ask
Yeah.
I'm sorry to interrupt, but can I ask Taya to just give a little more detail on Raoul Rothblatt's request? Thanks.
Sure. Chair Gordon, is that okay? I can do it quickly.
And I'll just throw out in addition that there is an informal dog run, if you want to call it that, over in University Park, right by Flatbush Avenue Extension and Willoughby Street, the little triangle there. And that's where the dog owners do go. The pigeons go there. People go there for walking around, doing things. So there is a place right now in the immediate community where the dogs can go and have a nice time with their people.
Okay, let me share screen really quickly. I'm only going to share this one
Okay.
visual. I'm happy to take questions though. So just to orient people in place and time, this presentation was given to the board in January 2021, approved and then passed forward to this was the presentation given to PDC. So this is Duffield Street on the left and Willoughby across the top. It's a little bit cut off, right? So just focus your attention, please, on the lower left corner of this design. And Daughtry, you could maybe speak to some elements of the design as well. Essentially, so this white blank square right here, that is 227 Duffield. Immediately north of this space, immediately north of 227 is the former site of 225 and 223 Duffield. It is a matter of scholarly consensus that 227, 225, and 223 Duffield were one, originally owned by members, by abolitionists, and two, that there were a series of tunnels underneath those three addresses that were connected to each other, used to connect the three buildings to each other, and further connected to the church, which is no longer standing, which was just past this portion of the diagram. Following a public petition, I think it was like 18,000 signatures, 227 Duffield was preserved, is currently owned by the city. There is some concern about the state of the building, which has experienced some significant damage to the back end recently. Doesn't seem to be related to the construction, it's just related to the age. And frankly, you know, no funding from the city to repair the building. So Mr. Rothblatt has been very persistent, and I would say a pretty diligent citizen researcher on this topic for many years. Just to show you what the current topic is. So this white square is 227 Duffield. These little gray squares, these pavers, represent a very narrow walkway. And this beige square right here is the proposed dog park, as you can see in EDC NYC's own diagram. And Mr. Rothblatt's opinion, which he brought to the committee, is that it is inappropriate for a dog park to be situated above buildings and historic sites of significant national interest. I hope that was an okay summary.
I think it's a very good summary. Thank you, Tanya.
Tanya, I'm sorry.
Tanya.
I'm sorry, in the letter that you sent out, it says it's up to the committees to determine if we want to give a letter of protest. So are we being asked? I know you said one committee already gave one. Should we, land use, be voting on this now? That's what I want to know.
Good question. You do not need to do that because your colleagues in the Yucca committee already, actually unanimously, supported this letter of protest. So the full board will have an opportunity to vote on it at the December 8th general meeting. Now, the note that we shared with Mr. Rothblatt is that we know just from walking by on the street every day that the ground was already broken last week. So December 8th may or may not be too late for a letter from a purely advisory committee. Mr. Rothblatt is aware that the community board does not have the authority to issue a stop order. So he is also pursuing with the Mayor's Office of Community Affairs and a contact at Brooklyn Borough Hall. So if this topic is of interest to you all, he has made his contact information available. It's in that letter that was shared with you.
Tanya, I did read the letter. This is John Dew. What I wasn't clear about is why did he take so long to submit it, given that these plans were approved for over 2 years now or so?
I can't speak to that because, you know, Mr. Rothblatt isn't here. He has been very persistent with the office and we have been in communication with him, at least as long as, you know, almost 2 years now that I've been with the office. I think one issue was that there was some confusion about, just to give a little more backstory. So the artist for the site has been chosen. She is a known artist Camila Janan Rashid. She presented to the Parks Committee. There was supposed to be a series of public input sessions on the design taking place last summer. Those were postponed. In office communications with EDC, what we have been told is that EDC is working with DBP and DCA on a new series of public input workshops. Those have not been finalized or shared with the board, with the office.
Okay, and just as a point of fact, the size of the park has been reduced to a certain extent to accommodate all of the additional high-rise construction. So the design of the park currently has been greatly reduced and has had to squeeze in a whole bunch of important items in a much limited area. So it would be very interesting to see what the architect, if they adopted, does with that very tiny park.
Yeah, and I think that we're really fortunate, this committee is really fortunate to have an architect in your membership. So Ms. Karstafen, I hope that you will elevate any specific comments that you might have about the design or any particular placement, alternate placement of the dog park when the discussion comes up at the general meeting.
I will, and I will just say again that typically my experience is that when a challenge comes to a design of any kind and you take it into consideration, you end up with a better design in the end. And given the historic significance of what we're talking about here and how hard we fought to maintain the last standing 227 Duffield, I feel like it is an opportunity that can't be missed. There, to Mr. Duke's point, there is a lot of pressure on the park in terms of what it seeks to deliver. And I am not a landscape architect, but I know that it can be accommodated and we should take that into consideration.
From a historical perspective, it should be a priority for the park, which, by the way, will only get 15 minutes of sunlight a day, given the construct of 9 Flatbush Avenue.
I had no doubt that this committee would have strong and informed opinions, so we're happy to share it with you.
I just want to say that if any member of the committee feels strongly enough to move a motion in either direction, feel free to do so. But as Taya mentioned, it is not necessary, but just want you to know that you can also do it if you so choose.
I would like to make a motion. I would like the motion. I would like the motion to be that the EDC and the design committee reconsider the location of the dog park to allow the park to bring attention to the historical significance of 227, as well as the other structures that are no longer standing, and to the history below grade as well.
A second.
Carolyn, does that motion differ significantly from what the other committee put forward?
Sorry, I was not at that meeting, but I see that Taya says the language is almost verbatim.
Excellent. Okay.
But it can be a joint recommendation. Fine.
Okay.
All right, we have a motion to I guess it is a support. Yeah, go ahead.
Did we vote on it?
Sorry to interrupt. I just want to clarify what the language is.
Yeah, okay. Yes, please. I was going to ask you that also. Do you need a clarification of the language, Brian?
I do. I just wanted to make sure, I believe it was to EDC and the Design Commission, but I wanted to make sure I understood these stipulations that Daughtry added.
This is the hard part. So yes, so I'm asking that the design reconsider the location of the dog park to allow for really the amplification of the history of 227 Duffield and the other structures no longer standing, as well as the structures below grade. I think that's what I said. Is that what I said, everybody?
I think so.
You have the gist.
Yeah, sounds good to me.
Thank you.
My question about Carol Ann's suggestion is, I'm not sure which is stronger, to have two separate letters to support the protest of the location of the dog park, or to be a joint presentation.
One
just the
letter
fact
is
that-
fine because the
Well,
letter, I'm sorry, the
had
letter
asked that.
comes, the letter is going to come from the community board, not from the committee. So it will be one letter. However, you know,
Okay.
although the text doesn't differ, we can still say that two committees voted to.
So should we
That's what I
vote?
was about to say. Yeah. Okay, so we have the motion. I think it's very clear and it's in support. And it's asking for help from the, or at least consideration from the EDC and the City Design Commission. And any other comments or questions on the motion? Hearing none, I'll run through. I see, well, I'll go what I have here on the little screen. Hazra Ali,
Yes.
okay, John Doe,
Yes.
okay, Daughtry, I imagine it's yes,
Yes.
it's your motion. Okay, Julie Stanton,
Yes.
okay, Esther Blanc,
Yes.
Brian Howard,
Yes.
yes, okay, and Alan Washington.
Yes.
Yes, okay, so we have a 1, 2, 3, 4, 5, 6, 7, 8, 9, and me, yes. So that's 9-0, 9 in favor of this motion. So we did a little extra work here. Just wrapping up community forum. Is there anybody
Sorry.
else from the community?
Sorry to interrupt. I count 8. Did I miss somebody?
Okay, maybe I would, okay, miscalculate. If you count 8, that's fine with me.
That's 8. I confirm 8.
Okay, my error. Any other comments from community members? We're still in community forum. Hearing none, motion to adjourn.
No, we're not ready to adjourn yet. We're not ready to adjourn yet. The issue of 227 came up, and we should actually find out what's happening with that. What is the status of it? And we should actually be a bit more vocal about seeing that funding is provided to restore that building and whatever else underneath might be relevant.
So I can address that just a little. And things move quickly, so my information might be a little bit outdated, but sometime maybe back in September, I was contacted by, gosh, I can't remember his name. You might be familiar with him. His first name is Jacob. And he alerted me to the fact that the building was not closed and there was weather damage. I contacted Department of Buildings, I contacted EDC, and they referred me actually to DCAS. And they said that an RFP was out. They had a contractor assigned. I did ask for them to seal the building prior to the work being done because they didn't have an actual start date. The constituent reported that it appeared that there had been some sealing done. But at this point in time, I know the RFP has been issued, as I previously said, but I'm not sure what work is being done. But the first job was to stabilize the building. So I will follow up on that.
Would you please, Carolyn, and what they plan to do with the building inside would be helpful to know also.
Okay.
That, do we have anything, other matters?
Carolyn is going to share the language that came from the controller's office about community board participation so that we can all understand what we interpret it's trying to convey. That's it.
I defer that to the board chair, actually.
What, the sharing of the language?
Of the report.
Controls are-
Please understand, Mr. Du, that I am the community coordinator, not the district manager.
I understand that, but you
So-
shared that you got a document that said the
Yes.
community boards need to do something that we are currently doing or not doing. And I'm not quite sure if we're doing it, what the purpose was if we were doing what the controller says the community boards need to do. If we're not doing it, I'm not clear as to what it is we're not doing. So
I understand, but I will actually let the chair get first dibs at, the board chair of speaking about it.
fine, absolutely.
I agree. I think that should be, we'll leave that to Lenny Singletary at our the next time we meet with Lenny Singletary, and we'll get the final details from him. Again, is there any other matter? Again, we ask for a motion
So
to
moved,
conclude our tonight's meeting.
so moved.
Second, I'll second. Thank you. Thank you, everyone. Thank you, Brian Howe, for doing the minutes on this one. I know it's always tough. I've done minutes and it's a lot of work. So thank you very much, Brian.
No, I definitely got the one, as Dashri said earlier,
Yeah.
I definitely got one of the easier assignments.
You got one of the easier agendas, yes. Yeah, next month, who knows what'll come up next month. We'll see what we get. Thank you, everybody.
Happy Thanksgiving.
And have a good holiday. Yes, have a good Thanksgiving holiday.